Hi, everyone. Welcome to another edition of Divorce-a-Palooza. Many people think that a divorce trial ends in a big courtroom drama like you see on TV, but in reality, most cases get settled, often through mediation or lawyers just reaching an agreement with their clients before they ever even go to trial. So, having said that, there are some cases that go to trial, and that's what we want to talk about today. My guest is Turner Thornton, a partner at Varghese Summersett, which is a wonderful law firm in Fort Worth, Texas. So, hi, Turner.
Hey, Jackie, good to be back.
Nice to see you as always. And, Turner, tell people who are watching, how long have you been a divorce attorney?
So I actually have only ever done family law, which I think is probably unique, at the very least for male attorneys for whatever reason, at least in my generation. So I graduated law school in 2012, got into family law immediately, and have been doing it ever since. So,
All
gosh,
right, so
a little
so
over a
12
decade.
here. Okay, now do you is there a percentage I've heard that only 5% of divorce cases go to trial? Is that like true? I know it's different in different states, but does that sound about right?
I would say, if anything, it may be even less. To
Mhm.
anecdotally speak, I've gone to final trial only once in 2024. And as far as settling cases is concerned, I've probably settled, I don't know, 50 to 60-ish this year.
Okay. Now, but some do go to trial, and all cases start out as if you're going to go to trial, right?
Correct.
I mean, theoretically, everyone's headed towards a trial, but the hope is that you can settle in mediation or just settle with your attorneys.
100%. Really, when you're going through an initial consultation with your lawyer, it should be, at least in my opinion, approached as if you were eventually going to end up before your judge or jury in a final trial setting. That is the ultimate goalpost with which this process ends. There are many different avenues that you can land or that you can fork off of the main road to either settle at mediation, potentially settle informally without going through the formal mediation process. But if push comes to shove and the two parties and the attorneys and anybody else that's involved can't come to an underlying agreement, eventually you're going to get in front of a judge or a jury and have your trial heard.
And so, who are these people? When can't somebody settle? What kinds of people? I mean,
That is a tougher question. I would say any question that I'm ever asked, I tell my clients there's one answer, I guess two possible answers, which is reach an agreement or go ask a judge. At least here in Texas, Texas is a one-party consent state, which means you don't have to be in agreement with the other person to eventually get your divorce. In other words, you may not agree with your to-be ex-spouse on a child support figure, possession and access, maybe how something property wise is going to be divided up. You have the ability to settle on a handful of issues, but if you can't settle everything, you're eventually going to get before a judge. You end up having folks that, at least in my estimation, kind of pick what's most important to them. They'll prioritize their list with their lawyer of, I would rather have more time with my children than get X amount of dollars or something like that. So if you end up actually in front of a judge, depending on what you have settled or what you haven't settled, you could be telling the judge and the jury every single thing about your life and asking the judge or the jury to make all those decisions for you. And not because you don't want to make the decision, but because you couldn't come to terms with that other person.
and is this usually like when I said what kinds of people? Like, have you seen people with like substance abuse issues or just somebody who has a lot of money, who's just super angry and just doesn't want to settle? Like, that's what I'm talking about.
Follow. So I will tell you more often than not, if you're in an actual trial setting, it's because one person usually won't agree to the status quo. And what I mean by that is, let's say, for example, you have a stay-at-home mom, a dad who is working and is gone frequently, and the dad, in this instance, is asking for primary custody of the kiddos. Practically speaking, that probably doesn't make sense, especially given the fact that the way that these folks have led their lives, mom has had the children primarily. But for whatever reason, they won't accept that. And they say, no, I think it's better for the kids to live with me. And mom says, of course, I'm not going to agree to that. That hasn't been our lives nor our children's lives for years. So trial is it's a tricky ordeal, but I will tell you in my experience, more often than not, it's because there is one primary fact that is obvious that someone just won't give up. And because of that, they want the judge to be the person to say, no, this is how it's going to be.
And what a shame because you're wasting so much money. The person is just letting their anger dictate their checkbook. They're writing all these things. It's a big waste of time, really, because it's like a formality. Of course, the judge is going to rule in the status quo.
Exactly. It is, you don't pay a dime to chase a nickel, right? So it makes no practical sense to pay your lawyer. And I tell folks this all the time. As much as I enjoy the business, it's not good for you and it's certainly not good for your kiddos because the amount of money that it takes to go into a final trial, I'll tell your audience, is substantially more typically than it is to settle your case, at least as far as the fees are concerned. So
Absolutely.
ultimately, if you're ending up in trial, you're probably spending upwards of five figures to have a third party who's only going to hear your case for so long make life altering decisions for you. You need to be committed to that decision because it's an expensive one.
And then what happens after the trial? A lot of bitterness, not a good co-parenting relationship, a lot of anger still, resentment, the kids feel it, and then maybe post decree because people aren't adhering to what the judge ruled. They're like, "Well, I'm not going to pay this, so I just won't pay." And I've seen it firsthand and I did not go to trial, but I once chased $2,000 and it cost me 10 to get the 2. And then all of this other stuff came up and it was a huge mess. And so I want everybody watching to, don't do what I did. I mean, and I learned from it
Sure.
after that.
The mechanics of a trial necessitate that you can't put the toothpaste back in the tube. So to your point, as far as a co-parenting relationship is concerned, if you're going through the settlement process and you're successful, it means that a world does exist where the two parties can see eye to eye, or at least are willing to work with one another. If you're going to trial, you have to, by nature, air your grievances. You have to tell the judge, a third party, why this person should not have, in this hypothetical, more time with their children. You can't unhear those things. So, despite always having an internal struggle with your spouse, when you throw it out to the world in an open courtroom about why this person shouldn't have time with their kiddos, it's impossible to unhear it. And because of that, it makes co parenting successfully in the long term, in my opinion, substantially more difficult.
Absolutely. All right. So there's two types of divorce trials, and we're talking about Texas here, but you would have to check with your state, but we're just going to say Texas. There's a jury trial and a bench trial. And does anybody ever have a trial where a jury hears their divorce case? I didn't think that was even possible. And then a
It,
bench trial is just where a judge hears it.
Correct. It is incredibly uncommon to have a jury trial, at least here in Texas. I've been doing this, like I said, 12 years now, and I've done one jury trial, and it's a week long. Part of the reason I think is twofold. As you would assume, a jury trial is most likely more expensive because they're longer. You have to prepare a bunch of different types of motions, similar to a criminal proceeding, about what comes in, what comes out. You have to do the jury process, the voir dire, as we call it. So all of these things end up just costing more money. In addition to that, there's only so many things that a jury can actually decide. So they can potentially choose who has primary, meaning who has the children more often than not. But as far as rights and duties are concerned, so decision making abilities for the children, the judge is still going to make those decisions. So you're throwing up, I will call them big ticket issues to the jury, but all the minutiae is still going to be worked out by the judge. At that point, you have to decide, is it really worth it? Or do I need to go in front of a judge for everything? And you can figure out, oh, this person, at least in theory, knows what they're talking about, is well versed in the law, potentially was a private practice attorney practicing family law before they took the bench as a judge. They tend to be, at the very least, more knowledgeable. And because of that, at least as an attorney, they're easier to predict. Juries are wildly unpredictable. Judges are much more predictable. And therefore, as a lawyer, you can advise your client, I have an idea what this judge is going to do because historically that's what they've always done. If you throw yourself in front of a jury, you are at the mercy of strangers.
Okay, but how do you even decide? Do you say, like, can a person say, a lawyer, we want a jury trial, or does the judge decide? How does that work?
Constitutionally, everyone is entitled to a jury trial if they want it. So specifically here in Texas, and I'm in Fort Worth, Texas, which is Tarrant County. It's one of the larger counties in Texas. What we do is we have to specifically ask for a jury before the court. So there's a box that has to be checked paperwork wise, and I won't bore your audience with it, in which you ask the court, hey, I want my case to be heard before a jury. You can't mandate all of the various things necessarily that the jury can or cannot decide. That's decided by code. The Texas Family Code dictates how all this stuff goes. So you have the ability to ask for it. If you want it, you are entitled to get it by law. The reality is, like I said, most folks don't want to go through that process because it is exceedingly expensive and because it's likely going to cost you with your lawyer a lot more fees. And you're going to have even more folks that are hearing your business that you may not want to have hear your business.
Okay, moving on to what if somebody is listening to this or watching it and they're feeling like this is now looking like we might go to trial. It's been a long time. I've been going through this for a year and a half. We're still not agreeing on things. Tell me what the process looks like.
I can tell you specifically that conversation needs to happen well in advance of your possible trial date. So, usually, at least here, we go to mediation depending on the case, either early or kind of midway through the case. You will only sometimes go toward the end of the case, closer to trial, if it's been really contentious, meaning y'all aren't on the same page about anything. In my opinion, it's really important to talk to your lawyer or your counsel or even your community, whoever that may be, your divorce coach or somebody like that, about the realities of what going to trial means at least 3 months in advance. And the reason being is, like I've mentioned many times at this point, it's expensive. So it's likely going to need some financial planning in order to afford going to trial. And it's important to have a pros and cons list with your lawyer. Is it worth it to you to go to the court to achieve X, whatever X may be? Or is it more likely than not helpful to you as a litigant to decide, well, I don't know if it's worth it to me because I may just end up in court on a modification 2 years from now or a year from now or whenever it may be. So maybe I settle and agree on some of these issues, knowing the other side is probably going to take me back to court in a few years anyway. Those conversations need to happen, in my estimation, throughout the process, but certainly no less than 3 months prior to that final trial date.
And how about preparing the people for being a witness, right? I mean, I would think that would take weeks, if not months. Like, here's what you're going to, let's talk about how you're going to answer this question, right? I mean,
It is imperative that the lawyer has their client or possible witnesses ready to go substantially before the trial. And part of that is, in my opinion, it gives a litigant, a party, an idea of what they're about to get themselves into, right? It's easy to say when you're just talking in a room, this is what I'm going to ask you. Here's how I think you should answer it based on the facts, right? It's totally different if I'm cross-examining my client in a fake mock trial in which they've never felt the heat of somebody else questioning them. It's
mhm.
possible for folks to go through the process and never get before a judge or never answer questions in a witness box until they're at their final trial, which is crazy to me because you don't have a clue what it's going to be like from an emotional standpoint until you're up there. So it's
And even if you practice, when you actually get up there, you're so nervous because it's the real thing. That can come into account too. And you could end up saying, not doing well because you're just so nervous when the real thing happens.
absolutely, you can take as much batting practice as you want, but until it's you against the pitcher and he's throwing 95 and there's 50,000 people watching, you may not be ready for the moment. And that doesn't mean that you're a bad person. It means that you're inadequately prepared, and which could end up haunting you with what the judge decides to do, or potentially the jury.
And which is also the difference between a good lawyer and a not so good lawyer, because I just heard a story of a woman who went to trial and her lawyer called her 2 days before the trial and said, okay, come into my office. We'll spend an hour talking about what you're going to say. That should have been a 3-month conversation.
Absolutely. Well, and to that end, depending on how long the trial is, there's so much personal life that we all live. And if you're in front of a judge, you may only have 6 hours to tell your entire life story, or at least your marriage story, and you have to convince the judge of what you want the judge to be convinced of. So, does it make any practical sense to only have those conversations with your lawyers 48 hours in advance of having that
Right.
conversation in front of the judge? Probably not.
So I think the whole takeaway of what we're talking about is really, if you can, try to avoid a trial. And Turner, what are some things you can tell people if they're really angry and resentful and they say, but I want to have this end up fair and I want the judge to hear what I have to say. How do you answer that?
I understand why some folks want their day in court. To some extent, depending on how their attorney approaches it, that's what they think they're paying their lawyer to do. During an initial consultation, I tell my folks all the time, you have to decide what you're buying from me. Are you buying from me legal counsel? Meaning, I'm going to coach you on what the law and what it says. Are you paying me because you want your day in court to put that other person up on the stand and make them answer for their sins? Because in theory, those live in two different parallel worlds, right? So you have to be constantly communicating with your lawyer of your expectations. Your lawyer needs to constantly communicating with you of what your expectations could or potentially should be given the process, given the court that you're in, and given your facts. Because at the end of the day, you may really want to go to court and have the judge hear your side of the story, but your entire community and your legal team may be telling you, not so fast. I don't know if that's the best idea given the facts of the situation. It's a difficult process to really wrap your brain around, not to mention an expensive one. So more than anything, I had a mentor once say, to use the 5 Ps. Poor planning precludes poor performance. And what I mean by that is if you don't plan and you don't have a game plan going into your case, let alone trial, it may not go the way you want it to.
100%. And I want to close this out by saying to people listening, divorce isn't fair. So don't go to trial because you want it to be fair. It's never going to be fair. There's too many things that intangible. So it's never going to be like 50-50 exactly. But instead, look at it in a as smart a way as you possibly can. I want to get out of this with, and here are my things that I want the most. Here's some stuff I really don't care about that much. And here's stuff that I don't care about at all. If you tell your lawyer that, your lawyer then will maybe act like you want the other stuff and then act like you're doing the other person a favor by giving it to them. So I don't want to say it's a game, but be smart about it and really um trust. If you trust your lawyer, then you're going to turn out fine, so much better than if you go to trial.
I think the reality of family law, much like you said, is there is no such thing as fair. Because ultimately, if things would have worked out differently, you probably wouldn't be going through the little litigation process in the first place. And so you
Mhm.
have to maintain that mindset. What you were going through is an emotional beatdown, a financially draining process. So going in expecting that a trial is going to cure all of those woes is unrealistic thinking. So go in with the proper mindset, and ultimately, I think everybody will end up being okay.
Turner, thank you so much for taking time to be on Divorceapalooza.
Thanks so much, Jackie. It was fun as always.
And if you want to talk to Turner, if you want to call him for a consultation, the website is versus.texas.com. You can also find Varghese Summersett in the trusted professional section of Divorced Girls Smiling. Thank you so much for watching, everyone.